Number 10 is here
Okay,
on the two slide.
okay, first seven, you gotta have them sit in the first 7 seats. That's Ms. Hamill,
Yes.
and Ms. Bob is gonna sit next to Ms. Hamill. Mr. Matthews is next to Ms. Bob. Mr. Reynolds is next to Ms. Matthews. Kay Wall is next to Mr. Reynolds. You, Ms. Wall? Number 5, Kay Wall. Kay Francis Wall. Okay, let me do this here. Jacqueline Hamill, please raise your hand. Joanne Bob. Kirk Matthews. Mark Reynolds. Okay. Who's Lauren Bradford? Sit in the chair. Yeah, sit in that chair. And Miss Sandoval will sit in that chair. Is that Colvin? I'll sit in that chair. Yes. Once you come on up, there's a chair that's empty. That's your seat. So you're gonna get Larry Crouch. Yes, that's Miss Billy Colvin.
Number 9, Mary Trout.
10 is here. Larry Crouch. Sit next to Miss Colvin. And Miss Randall Fowler. Sit next to Mr. Crouch. And Edmondson. Sit next to Randall Fowler. That next chair is gonna be blank. No,
No,
you good. Yeah, and that's Miss Campbell. And Miss Pate Tatum. I'll sit on the end. Okay. Is that Miss Rodriguez, Gonzalez Rodriguez? And then Miss Erica Schuler?
Yeah.
Richard Allen?
Yes, sir.
Michael Rutherford? Who is Michael Rutherford? You, okay, yes. You'll sit next to Mr. Allen. Yes, I'll sit in the chair next to Mr. Allen. Thank you. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes, and I'm the presiding judge here in County Court at Law number 2. You have been summoned or asked to come to court today for inclusion in a misdemeanor criminal case. Our courtroom hours are normally from 9 to 5 p.m. Whether you are selected as a juror today or not, you are performing a significant service that only free people can perform. If you are selected, this case will be tried expeditiously and consistent with justice, which require a careful and impartial and correct trial. If selected on the jury, unless otherwise, you will be permitted to separate at recess, for meals, and at night. Now, I must administer to you the first of 2 administrative duties. So at this time, I need each and every one of you to raise your right hand. And once I finish administering the first oath, I need each and every one of you to say, I do. Now, do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a juror? So help you God. Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions that some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, the case could be retried, and you may be held in contempt of court and placed in jail for up to 180 days and fined for up to $500. Now, the way I'm going to ask the questions, I'm going to ask a series of questions. I do not want you to answer them out loud, just answer them to yourself. And then once I ask the last of the series of questions, I will then ask, is there anyone disqualified under the law? And if you think that you may be disqualified under the law, I just will ask you to simply raise your hand, and or we will ask that you will come up before the bench. This is the bench, so that we can discuss the matter more privately. And when I use the term more privately, what I'm talking about is we're going to turn off, we're currently on YouTube, we're going to turn off YouTube, we're going to turn off the mic, and we'll put on this device. And then we'll be able to discuss the matter more privately. Okay? So the first of the series of questions is as follows. Except for failure to register, are you a qualified voter in Jefferson County and Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause when I ask this next question. And the next question that I have to ask, we have to ask it because it's required by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under law? If you think that you are, please raise your right hand. Okay, we have 2 people, that's 3, 7, okay. Next at the juror number 3, that's Mr. Kirk Joseph Matthews, is that correct? Mr. Matthews, you can come forward, and we can ask the lawyers to come forward. Okay, ladies and gentlemen of the panel, now I will determine if any one of you who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. Now, at the end of this series of questions, I'll ask the questions like I asked the previous set. I'll ask in a series, and then when I ask the last question, I will then ask, is there anyone here who would like to claim one of the exemptions? The first question, are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, officer, or other agency, office or other agency in the legislative branch of the government? Have you served as a petty juror in the county during the 3-year period preceding the date, which is today's date, that you appeared? Are you the primary caretaker of a person who is an invalid, who is unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed away to a location from your home station and out of Jefferson County? Now, if any of these exemptions apply to you and you wish to claim one of these exemptions, just please raise your right hand. Okay. Let the record reflect that no one on the panel raised their right hand. Now I will move on to excuses. And then under excuses, I will not ask a series of questions. I will just make some statements, and then I will ask if there anyone who would like to claim an excuse after I finish making the last statement. A juror may be excused for observance of a religious holiday upon completion of an affidavit as required by the Texas Code of Criminal Procedures, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be claiming an excuse? Let the record reflect that no one on the panel is claiming excuse. All the jurors are qualified to serve as jurors in this case. Let the record reflect that the time now is 2:37 p.m. on today's date of October 3rd of 2023. The court is convened in the case cause number M331930. The case is styled the state of Texas versus Catherine Cormier or Cormier. Ms. Cormier is present in court with her attorney, Attorney Wright Kimbler. The state is present with Assistant District Attorney Kobe Hallpower and Courtney. At this time, the defendant, well, the court reporter in this case is Miss Ada Christie. And please speak up when you are being asked questions or you're answering questions so that the court reporter will be able to hear, because she's taking down everything that is being said. The bailiff in this case is Miss Veronica Woodle. She's in the back, and she will be keeping order in the court. The defendant, Miss Catherine Cormier, is charged with the Class A misdemeanor offense of resisting arrest, search, and transportation. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more privately with the mics off and the sound device on. Is the state ready to proceed? Is the defense ready to proceed?
Already.
Mr. Hoffbauer, you have 30 minutes and the court will be keeping time.
Yes, Your Honor, I believe, Ms. Satan's gonna move, so. we're gonna wait.
Oh, okay.
This counsel, Joseph.
Yes, you may proceed.
Right, good afternoon. How you doing? All right, we can move in that. Everybody good? All right. I know it's been out there. It's been drudgery of waiting. Hurry up and wait. We apologize. We're doing things in here, I promise. And not just wasting time. We got a lot of cases set on the docket, and then it comes down to the one we're gonna try. Well, that's a process. Okay, so we apologize for you waiting, but we're doing important things. And we want to make sure you understand, by you being here, okay, that's how we move our case. We don't have a jury ready to go. These cases don't either plead out or go to trial or anything. We don't have a jury in our system, which is important. So we can't do this. So we appreciate you coming, all right? What I want to do, so I don't forget, is if you have people like in your neighborhood, or family or friends that are like, what does this matter? Tell them, hey, come down, we need them, all right? We need them to be jurors, okay? We need them to participate like y'all do, okay? I don't have to tell y'all that, but bring people like smart ones and like-minded ones, okay? Bring them down, and we need them for jury service, okay? All the courts in Jefferson County, okay? That's how our system works. If we don't participate, then it doesn't work that way. You understand? So thank y'all for doing that. Right, my name is Kobe Hoffbauer. I work for the Jefferson County. I'm an assistant district attorney in Jefferson County. Okay, we work for me and my co-counsel, Ms. Courtney Davis, who I've worked with for a long time in multiple counties. We work for Keith Giblin, who's the elected DA here in Jefferson County. He was a former federal magistrate. Okay, he just took off. And we work at his pleasure. We're assigned to the misdemeanor courts. Okay, this is where we try Class A, Class B misdemeanors. Okay, y'all familiar with misdemeanors? Y'all heard that before? Felonies are right next door. Okay, a little bit more serious. They have prison time. Ours deal with county jail time. Okay, but they're just as important. They're crimes. Okay, it's not like a traffic. It's not what it is. Okay, now just told you that we're here on a resisting arrest transport, resisting arrest search or transport. Has anybody not heard of that kind of charge before? Let's start there right now. Mrs. Kim, you ever heard of resisting arrest? Yes. Okay, well, tell me what you think resisting arrest means. I'm gonna give you the definition, but I'm gonna let you do that. Now, you're a teacher, right? Retired teacher. Yes. Both my parents are retired teachers, so I know what kind of house we're gonna do.
Ever officer, someone from the law,
Yes, ma'am.
tells you to stop.
Yeah.
Doing whatever, you don't.
Okay. Okay, that's a good example. Everybody here on the Samuelson. Okay, that's a good example. And I'm gonna give you the definition of it and elements we got for you. Okay, all right, now. Resisting arrest, search, or transport. These are the elements I gotta prove because the state in criminal cases, I gotta prove each and every one of these elements beyond a reasonable doubt. I've heard that before. Okay, because it's on me to prove that. So it's not like a civil case where it's about money. No, we're not talking about that. We're talking about criminal cases where it's beyond a reasonable doubt and I have to prove each and every one of those elements. If I understand. Okay, so I gotta prove the defendant on or about a certain date in Jefferson County, Texas, did intentionally and knowingly prevent or obstruct a person the defendant knew to be a peace officer from affecting an arrest, search, or transport of that defendant by using force against the peace officer. Okay. Now, what Ms. Hale said was prevent them from being arrested. Right? Okay, we're talking about that. Now, we've got two different laws. We've got an evading arrest charge. That means if you run, right? So you're right. I'm following with you, Ms. Hale, like from running, I don't use force, I'm just running away. Right? That would be evading arrest. Everybody clear? Got that? This is if they know it's an officer and they're using force to get away. Okay? Using force meaning pushing them away or knocking a hand away, force, okay? You know what I'm saying? Everybody got the difference between evading an arrest versus resisting arrest. Now, both of them are class A misdemeanors in the state of Texas. I've been doing this so long, one of them used to be a B, class B, but now both of them are an A, okay? But that's two different charges, right? Are you with me, Ms. Bob?
Yes.
Okay. Now, prevent or obstruct, these are the definitions that are given within the law, okay? To prevent means to stop something or keep it from occurring. That's kind of what Ms. Hamill said, right? Keep it from occurring. But to obstruct means to make progress or activity difficult. To stop somebody to make an arrest or detain or to transport, like if they're transporting them from maybe a crime scene to the Jefferson County Jail. Am I with me? Okay, anybody lost? Please, this is the time you gotta say, hey, whoa, we're moving too fast. And I've been accused of talking too fast. I apologize. Trying to fit it all in. We need to talk about, okay? But arrest, search, or transport. Now, these are very specific terms, okay? Anybody not heard those three words before? You know what an arrest is, right? Put the hands behind the back and then where you going? Yeah, usually jail, right? Okay. Now, arrest is taking of a person into legal custody by law enforcement. You must have probable cause, okay? Now, search is an act of searching or investigation by law enforcement. You ever heard of somebody searching their car, Mr. Matthew, everybody, a search of a car? Okay, like if you're looking for whatever reason, you have suspicion that a person's carrying something in their vehicle, right? You may be searching if you have probable cause to search that. Okay, now, if somebody prevents that by force or preventing it in another way, that could be resisted, right? Everybody with me? Okay. Now, oh, yes, ma'am. This one.
I don't understand.
Okay,
I'll repeat it.
go ahead. When regards to if they prevent the search of a vehicle, meaning like, say, the officer has probable cause, okay, but you step in front of them, and you can't touch my vehicle, you can't get in there. That would be resisting, using force if you're pushing against the officer, right, or preventing them from searching. Right. This covers all things, meaning resisting arrest, resisting the search of anything, even their person. If they pat them down, that's another good example. If they pat someone down, right? Okay, to see if they have contraband is what we use, right? But they have a drug or a weapon, right, for officer safety. If you prevent them from looking in their pocket, like close it down and say, no, they ain't looking, that would be resisting. Okay, like, that makes sense, everybody got that? There's a multitude of examples, okay, but it all falls within this particular charge. Now, sometimes that gets confusing, I understand. So I want to make sure that when we're explaining it, that we're covering it. Because it all falls under resisting arrest. Search or seizure. That's all under that. Okay, everybody with me so far? Okay, now, transport, we talked about, is an active process of transporting individuals in custody by law enforcement to personnel such as suspects, detainees, or inmates. Okay, say you're already in jail, okay, and you resist being transported back to court, okay, because that's where you're supposed to go. That could be potentially resisting. All right, this is all, and I'm going to go over specifically what we're here for today. Okay, but this is the law, how it covers all of that. All right, and I'll make sure I want to cover everything about it, and then we'll talk specifically about something. Now, we can't talk about the facts of this particular case during this portion of jury service. Be ordered this down. Okay, so I can't talk about exactly what happened, but I got to talk about the law and how it's applied. Okay, everybody good? All right. Now, what kind of physical actions are enough to be considered using force? Mr. Reynolds, what would you give me an example of what, besides the one I used? All right. Okay, hitting, all right, now pushing away for sure, right? Everybody heard Mr. Reynolds said pushing away to get away, right? Strong arm, tell me what you mean by strong. Pushing away, keeping it at bay. Okay, keeping them at bay. Yes. Okay, like strong arm, keeping an arm away so they can't get close. Yes. Anybody think of anything else other than what Mr. Reynolds said? What about you, Miss Tam? Okay. Anything that uses force, right? Okay, I've got some on here that we're going to go through just for some examples, and those are good, the ones you gave, okay? But what about attempting to flee or elude peace officers? What do you think? Is that resisting? We kind of talked about it with Miss Hamlin. That would be fleeing, and we have a fleeing, and we also have evading arrest. Okay, that's more of that, right? Where's the use of force? Okay, if it's not there, then it's not resisting. Okay, but it might be evading arrest, and it might be fleeing or eluding police. Okay, now what about threatening an officer with physical violence as he's trying to arrest you, like using words? What do you think, Miss Wall?
Just saying, they're not gonna agree to do whatever
Okay.
you're asking them to do.
Now, is that resisting? What about, hey, sticks and stones, I break my bones? I know that my teachers, words never hurt me, right? It's words resisting. Can they be resisting? No, it's words used to force. It might be that, but words can't ever be resisting because they're not a use. You can threaten the use of force, and there are charges definitely for threatening a peace officer, right? But for resisting arrest, that's not, because it's got to be a use of force to prevent them from arrest or transporting forces. Everybody good? And that's why we're going over those, because they're little bitty things to make it. You understand? Everybody good with that? Okay, now, Miss Bradford. What about struggling with an officer while being restrained, handcuffed, or placed in a patrol car?
So,
You don't think that's not a use of force, like struggling?
they're already.
Well, yeah, but are they arrested or preventing them from being placed in a car or being transported after? Yeah, I mean, that's one of the ones that's on the line. You see what I'm saying? Like, we're struggling, what's struggling? Is struggling using force? Or struggling moving away like that to get away? Are you pushing against the officer? Or are you pulling away from the officer? That's the thing we talk about. You see what I'm saying? How that can be, that's important for those kind of, right? What do you think? You think, and it's okay to say, no, I don't think that's useful.
It just again, like you said, are they trying to get away or
Are they pushing you?
trying to?
Got it. Okay, everybody see what Mr. Bradford said? Everybody understand? Okay, just listen. Yeah, you look at him, you're like, man. Okay.
Yeah.
Okay. Now, what about physically attacking an officer that's trying to arrest you? Okay, now, that could be, but that's also could be assault on a peace officer. All right, now that is a felony offense. That's a third-degree felony, that's 2 to 10 years in the prison. Okay, you haul out and punch an officer. Assault, that's an assault, that's not using, I mean, that's use of force. I mean, it could, I guess it could be resisting, but it's sure assault on peace officer, right? That's a felony, okay, you see what I'm saying? All those things fall in the line, that's why we go down what they are, right? Now, the law gives us, and the courts have given us what use of force is, okay? This is what the law says, right? Texas courts have determined that any amount of physical force is sufficient for the purposes of a resisting arrest, search, or transport. Everybody understand? Any amount of physical force. It doesn't have to be go hop, you understand what I'm saying? It doesn't have to be a hard way. Any amount of force against an officer while they're trying to do their job, which is arrest, search, or transport. That's enough for resisting arrest. And that's what the courts have said. So that's what the law is. Everybody got that? Okay. Anybody got any questions so far? Perfect. All right. Why do we have this law? Miss Golden, tell me.
Just to maintain peace and order.
Exactly.
Avoid conflict.
Avoid conflicts if we can, right? Not to hurt. What about not hurting anybody? What about who we're trying to protect? Mr. Crouch.
Public in general.
Public. And the police. What about the defendant? Or the alleged perpetrator, right? No one's guilty of anything at this point. They're perpetrators. Okay, but it is to protect them. Isn't that fair to say? What do you think about this? I want to make sure Randall Filer, Miss Filer. Okay, now you're principal at the ISD. Okay. Now, is that to protect everyone, including the person being arrested? Is that fair to say, you think?
Yes.
Okay. Now, we're concerned about police officers for sure, suspects safety, and the public communities, general public safety. Okay, that's what they're peace officers. We ask them to go towards the violence. All right, when the call comes in, there you have to run towards that. Okay, so we want to protect them, right? But we want to protect everybody too, including the people that are alleged to have committed a crime. Okay, all those things. So therefore, force against them can exacerbate situations. Everybody understand that? And also, who has a gun on them? Officers do, right? That's a dangerous thing in itself, right? So we want to make sure everybody's safe. Now, what would you like to see in a resisting arrest, search, or transport trial to determine whether a defendant's guilty? Mr. Edmondson, we give you some examples of what you like to see in a trial like that. When I say that, we're talking about like types of evidence.
And might be suspected to be searched for.
Okay.
If there was, actual force or something trying to stop them from something like that.
Okay. Define if they were searching for something, I think they were searching.
Right.
Saying what you're saying, everybody hear that? Okay, now what about Miss Campbell, what do you think? What kind of evidence would you like to see in a trial like that?
You have to have a reasonable cause. Looking for something.
Okay. What do we, and just example, what do we know about officers today? Like what they have on? Like body cameras, right? Body cameras, they put body cameras and in-car cameras, right? Those kind of things. Okay. So videos that they have, all right? What about you, Mr. Tatum? What do you think?
That would be.
Okay.
Video of it.
You see it for what happened, generally officer, not all the time in the past that we have that, but now we do have that. Most of our officers have that, they have in-car videos, they have, a lot of people have surveillance video. Okay, if it happening near a business, or even in the school, right, for example, in school, it's about like, we have surveillance video about that. So if they had that, we definitely like to see that, right? Anybody think of anything else? Yes, ma'am, Hamilton. Witnesses, perfect, witnesses. Now, witnesses are evidence, okay, their testimony is evidence, right? So that's one of the things coming to testify. Okay. Anybody think of anything else? I'm gonna go through some stuff we might have, in-car videos, okay? Body cameras that officers carry right here. Okay, or right here. Either way, they're on there and they're connected to their in-car video. They're all in the same system using it. Now, testimony, Ms. Hamilton. Okay, now, who watches CSI, whatever city it's in, or who watches Law and Order, SVU, come on, everybody, and not just one, everybody raise your hand, everyone. All right, I do too, okay, now. Everybody knows the difference between television and reality. I promise you that this trial is not gonna be anywhere near as exciting as any SVU, CSI, okay? You understand that some of that stuff is made up as television. You know, if we had it, it'd be awesome, but it just doesn't exist, right? There was a former judge Judge Gist, it was a longtime judge here, and a lot of us, you know, I mean, Judge Gist speaks for himself. I mean, when he spoke, everybody listened. Well, I had a meeting with him one time about a case. He told me he was talking about these shows, and he told me one time, he goes, "Yeah, I watched one the other day where they found fingerprints on sand at the beach." All right. And I laughed, and I said, "Gentlemen, you know, gentlemen, steal that from me. I hear that every time. I never heard anybody explain anything better than that. That's ridiculous. All right. It just doesn't happen. All right. Now, so like a DNA, some DNA of a resisting arrest case, does that sound reasonable? DNA evidence on that kind of stuff. Yes, in a murder for sure. Yes, in a sexual assault of a child, but in a misdemeanor resisting arrest case, really, that's not reasonable. Everybody understand that? Okay. It also never in the history of real criminal justice has something been committed, arrested, tried, already in prison in 45 minutes conversions. It's never happened, ever. Okay, that's how TV works. That's not our reality. Okay. Now, if we have the testing and we have the ability to do that, we definitely should be held to that standard. Okay. Now, burdens of proof. We have reason to believe, okay, that's what we use in CPS cases. All right, there's reason to believe, that's what starts the ball rolling there. Now, probable cause is what police use to conduct a search, all right, or to make an arrest on suspicion of a driving while intoxicated. Everybody clear with that, what that is? Okay. Now, then we have preponderance of the evidence. Now, that is a civil case, all right? That means that 51%, all right, more likely than not, that's enough, okay? Everybody understand that? That's a burden of proof in a civil case. That's about money, ain't worried about any of that. That's all about money. This is about something different, okay? This is criminal law. Then we have clear and convincing evidence. Now, I want to make sure you understand, this is what we use in child custody cases down in family court, okay? But I want you to understand, though, that a lot of people give an example of like, what's the amount of evidence that you would like to have so that some of the court can come in and take your kids away from you, okay? Now, that's a misnomer, and what that is that's used, and that's not exactly what the standard. The standard is, what is the amount of evidence that the court needs to remove a child from an abusive home? Okay, you come into my house with a clear evidence, get my son with just that, you're gonna bring something bigger than what you got. All right, just to take him for no reason. Now, if it's an abusive home, yes, that's enough, clear and convincing. Well, make sure you understand that people don't just come and take the kids just to just clear and convincing evidence. It's gotta be an abusive home, and that's gotta be proven in court. All right, so. And then we have the highest one, which y'all have here, and that we have in criminal courts, it's beyond reasonable doubt. All right, it's the highest burden there is, but it's not insurmountable. Okay, you've heard beyond a reasonable doubt before, right? Everybody understand that? So we're going to go over it a little bit, but you've heard it before. It is the highest burden, and it should be the highest burden. Okay, but it is not insurmountable. Okay, it's not beyond all that. right? Now, let's go through that. Okay, our burden is beyond a reasonable doubt. It's common sense. It's used in all criminal trials throughout the United States. It's not impossible to meet, and it applies only to the elements, and I went over those elements for you. Okay, the ones we went down. Now, all right. What, everybody see the picture up here? See what it is? Okay, Miss Gutierrez Rodriguez, right? Yes, ma'am. It's Gonzalez Rodriguez. I apologize. Do you see the picture up there? Can you tell what it is?
It looks like a puzzle of a gun.
Okay, a puzzle of a gun. That's exactly what it is, right? Okay, now, is there all the pieces of the puzzle, are they there?
Yes, sir.
It's missing some of them. Is that right? Okay. Now, everyone sees the puzzle was missing pieces, but this is a good example of a trial, okay? Evidence provides the pieces of the puzzle, right? May not have every piece of the puzzle, but is there anybody who cannot see what that is? A puzzle of a gun. Is that right? Can you see that, Mr.? Is that right? Can you see that? Okay. Now, despite the fact that it's missing those pieces, can you still tell what it is?
Yes.
Okay. So, all right, reasonable doubt. Here's what we're going to talk about. Now, look, we used to be, and I went way before my time, but used to be able to give a definition for reasonable doubt. We can't do that anymore. Okay, courts won't allow us to do that. All right, so we have to prove our case beyond reasonable doubt. It never shifts to the defendant. It's always my job. And if I don't prove each and every one of those elements, what do you find on this? Right. If I don't prove each and every one of these elements beyond a reasonable doubt, what's your verdict? Exactly. And that's where it should be. Okay. Now, but if I do prove each and every one of them beyond a reasonable doubt, what's the verdict? Okay. So reasonable doubt only deals with the elements of the case. It doesn't deal with like what color a shirt is. All right, or what exactly time of night something like that. None of those are the elements of the case, right? Now, Texas law does not allow me to give you a definition, okay? But I can tell you what it's not, all right? It's not beyond all doubt, okay? If it was beyond all doubt, what would you most likely have to have been, Mr. Allen? What if you saw with your own eyes? Mhm. Well, no, but would it be beyond all that if you watched it with your own eyes? Right? Could you be on the jury if you watched it with your own eyes? No, you'd be in a witness stand, okay, not that big box, but that little box, right? Okay, so it's not beyond all that, right? Now, it's not beyond a shadow of doubt. Anybody heard shadow of
So
doubt?
how far are you at 5 more minutes?
Like, Judge. Shadow of doubt. Anybody heard that before? Does that interest you that that's a TV term? That's Matlock. Like, it's never been a real term when it comes to, legal in the courtroom. Only on television, okay? Now, best way to explain it, look, you'll know when you see it, all right? Every one of you got common sense. Every one of you doesn't have to have a degree in criminal justice to sit on the jury. When y'all checked in, when you put all your stuff in the box, the metal detector, do they have a box for your common sense? You put that in there and y'all left it? No, it didn't. It's still got it, right? So you can sit on the jury. Right? Now, all you need is common sense. That's it. All right. Now, will anybody require the state to remove all doubt the defendant's guilt? We went over that. It's just beyond reasonable doubt. Okay. Now, what about a higher burden of proof? This is the highest burden of proof, and that is beyond reasonable doubt. That's what the state's burden is. Okay. Now, does anyone know the defendant? No one ever heard of the defendant, Miss Catherine Cormier, or any member of her family? Everybody silence. No one does. How about her attorney, Mr. Ralph Kimler? He's been a long time attorney here in Jefferson. Yes, sir, Mr. Brother. You know Mr. Kimler? You don't mind telling us? I don't want to pry, but just how you know him. You know of him? Okay. And would that limit you in any way where you couldn't sit on this case as a juror and judge the case strictly on the facts presented? Thank you, sir. Appreciate that. Anybody else? Okay, what about me? You might know me. What about my counsel, Ms. Davis? Cool. Thank y'all. Now, prior criminal jury service, I'm gonna ask you these questions quickly. I didn't see a lot. Okay, I saw some that might have been on some civil juries. That's not what I'm worried about, just the criminal jury. What I saw was, I think, Mr. Tatum, you've been on the juries before. Was that here in Jefferson County? Okay, and was it a criminal jury that you were on? Yeah. Okay, and about how long ago? All time. And did y'all come to a verdict that day? Yes. Okay, and did y'all assess any punishment or the judge? Do you remember? Yes. Okay. All right. And anything about that case where you couldn't sit on this case and listen to the facts of this case, put that one out of your mind and be fair and impartial. Thank you, Mr. Now, looks like Mr. Allen, you sat on a jury before, is that right? Okay, was that here in Jefferson County? Okay, and how long ago was that? About 15. Okay. Was that in a felony court or misdemeanor court, if you remember? Was, okay, now did y'all reach a verdict in that? And did y'all assess punishment or the judge?
Yeah, whatever.
Maybe y'all gave.
What they said we gave, yeah.
Okay. Anything about that would hinder you from being fair and impartial on it? Thank you, sir. Now, there was one other person, but a grand jury. Is that Ms. Bob? You on the grand jury? When was that, man? If you don't
That
mind.
was, a while, it's been the grand jury was over, passed away,
Okay, yes, ma'am.
and you can come every Thursday.
Okay. So y'all are on a 6 month?
Yes.
Okay. Now, anything about, that's a little different than sitting on a jury trial, but you get to see a lot of things
Right.
in that. Now, anything about that would hinder you, or you don't feel like you could sit on this jury and put that out of your mind and listen only to the facts. Thank you, sir. Anybody else that I missed that may have sat on the criminal jury before? Okay. Now, important. Anyone who cannot sit in judgment on an individual in the context of a criminal trial. Okay, this is important because that's what a jury does. Okay? Now, it's okay for you, whether your religion or in any other way that it prevents you from sitting in judgment. You understand? But it's important that I ask that because if you can't, then we can't, then we have to do all this over again. I mean, you understand what I'm saying? I've had that happen to me in a sexual assault of a trial case. A child case, excuse me, where we went all week, and then at the end, we had an individual who said, I can't sit in judgment due to my religion. Well, that means to say, we got to do it all again. It's a mistrial, and then we got to put that victim back on us. So I give that example because it just as important. You got to tell us now, because it's the only time we can act. Everybody can sit in judgment. It's not a sin in ultimate judgment, obviously, right? It's just in judgment in terms of the criminal. Have I got that? All right. Any questions? Well, finally, look, as the jury, your job is to decide what the facts are. The evidence will be presented to you. You get the law from the judge. He'll give it in what we call a jury charge, and you apply the facts to the law. And you follow the law. That's it. Thank you all so much for your patience. Thank you for your attention, and I look forward to presenting the case.
Okay. Mr. Hawkar, you did 30 minutes, 32 seconds.
All right.
Okay, and you'll have the same amount of time. Mr. Kimball, you may proceed.
It'll be a break. Pick up. And get engaged, but. What do y'all think what Mr. Hawkeye was told in mind? Part of the law and all the stuff about what resistance is, or struggling, or arrest, or anything. I mean, y'all think that's fine on controls. Mr. Reynolds, what do you think about Mr. Hawkeye? Adoration of the law on the PowerPoint. Is that control, is that binding as a juror? So what is it? Well, I'm talking about the law, not the facts, the law, as far as what resisting arrest is and struggling, use of force. That is what he told you somehow binding, a binding statement of what the law is, what you're going to be governed by on the jury. Well, if I told you that you could totally disregard everything Mr. Hoffmeyer said, would you disagree with that? Would you feel empowered to do that? Now, let me qualify that. When I say that the law in this case that controls comes from the court, from the judge. He's gonna tell you what the law is, and he's gonna do that in the form of a written document called the charter. And that's what is the binding law, that's what controls, not what I say, not what Mr. Hoffmeyer says. So all of this discussion about proof beyond reasonable doubt, what resisting arrest is versus evading arrest, all of that doesn't bind you or limit you or control you. And to the extent that it contradicts anything Judge Holmes is going to tell you about what the law is, well, obviously Judge Holmes, he says, you can disregard anything as far as what the law is when it's coming from either parties. Mr. Hoffmeyer coming from me, because we're what, adversaries, an adversarial system. The law in this case comes from Judge Holmes. Now, I anticipate that he's going to instruct you that it's a criminal offense to resist by force, attempted use of force, public servant, law enforcement officer, when he's acting in his official capacity to effect an arrest, something like that. Now, I don't know if that's gonna be the exact language, but you get the idea of what resisting arrest is. Ms. And what did you tell Mr. Hoffmeyer? If the officer tells you to stop and you don't do it, that's resisting. And do I remember that right or not? Right. What do you mean by that? When an officer tells you, when a police officer tells you to stop and you don't stop, is that an offense in and of itself?
Maybe. I know if an officer told me to stop.
So what if you're out there criticizing some politician and an officer tells you, hey, stop, shut up? Is that a lawful? That's something you have to obey?
Nothing.
Well, I'm just asking you, do you think that you'd have to just shut up and
No.
go back
I
on?
don't have right.
So would you agree with that there's some limitations on what law enforcement lawfully can try to do? Right?
Certainly.
Sure. So it has to be what a lawful use. You think Rodney King had a right to fight that? Or did he just have to lay there and take the beat and not try to get things? Now, we're not talking about assault on the public servant, but do you think that just because a law enforcement officer is doing something, you have to just accept that?
No,
Sure. So you wouldn't have any problem looking at the lawfulness of the use of force, the lawfulness of it. And would you agree with me that the whole idea of a free society, when they empower law enforcement to control their activities, to give them the power to use force, to take people into custody, to arrest them, is the idea that they're going to use that reason? Anybody disagree with
well,
that?
they should.
Right,
It doesn't always happen.
right. But that's the idea, that we're free people, and we extend this authority to them with the understanding that they'll use it reason. Right, do they disagree with that? Now, do you think that you could look at the evidence in this case and the state presents it and be fair about that? And what if I ask you, you've heard the statement, I guess, back in the blue, right? Buy back the blue, and you see the stickers with the American flag and it's got the blue line on it. I guess that means I back the blue, black law enforcement, right? Are there limitations to that? You think back in the blue, back in law enforcement?
Well, I want to back our police officers.
To what point do you back?
If they're not breaking the law themselves.
And acting reasonably sometimes may not necessarily be Or acting unreasonably may not necessarily mean breaking the law, or is acting unreasonably always gonna be breaking the law? Be breaking the law. Outside of their capacity, official capacity. On a scale of 1 to 5, like 1 being strongly agree with the statement back to blue, and 5 being strongly disagree with it, 3 being just kind of neutral, where would you be on that? 3, neutral. Well, just on that statement, I'm only talking about this case, just in general. Back to blue. Strongly agree, kind of agree, don't have an opinion, disagree, strongly disagree. No, all right. Bob, what do you think? Agree, strongly agree, disagree.
I say,
What about you, Mr. Matthew?
Was it scale 1 to 5?
Well, yeah, or just whatever you think. I
Maybe
I'm not
5,
5,
strongly.
strongly agree.
Yeah.
You get 1,
So, yeah,
strongly agree. Back to blue, right?
Yeah.
What does that mean?
support law enforcement in the job that they're supposed to do.
What are the limitations that you see, that you would impose?
If they're stepping up bounds or not.
What is that? What's stepping out easy? What is action? What would be stepping? Give me an example.
Well, I don't know exactly. Do they swear an oath or uphold the law? And I would think a certain manner.
Well, give me like a factual situation, just from a
The
citizen.
Rodney King deal, that was, I've seen videos, probably overkill.
Yeah. And that was,
I wouldn't say that I would strongly agree to support the officers that are, kicking the guy 50, 60 times on the ground.
so at some point excessive force. Then.
Right.
What about a male officer conducting a pat down search of a female suspect?
Hmm,
And the female suspect resists.
what are the, I guess the reasons why they felt they need to do it? What the protocol would be for, maybe having somebody else there to witness it.
You need more information.
Yeah.
All right, what about you, Mr. Reynolds? Strongly agree, agree? Agree? So you'd be a 4, right? I'll ask you like I asked Mr. Matthews, can you envision a situation where you wouldn't back the blue and they're doing something?
They're doing something, so they run afoul of the rights, for unlawful searches and seizures. We're going to some place where we say we have the authority because we're in bad, the law constrains you in a way.
Well, Mr. Alcar kind of used an interesting example, I guess, we say, he's talking about proof, standards of proof, he talked about clear and convincing evidence and removing your child. Right? Well, let's say they show up and you're trying to remove your child, and you don't think there's reason for that, and the police are there. Would you be justified in actively resisting that? Unlawful, when you're being unlawful removal of your child?
Get complicated. It's not always.
But you would say as a general rule, like what they're doing.
Personal experience, the law enforcement officer has treated me with the same respect I have given him, so perhaps I have a different perspective.
Why do you think that is? What interaction have you had? Well, like traffic stops, or they, you call them for service, or what's that?
Yes, I've been, a victim of a minor crime, they have had a witness statement,
Right.
that kind of stuff.
What about you, Ms. Wall, what do you think?
I agree.
So 4, you agree, you strongly agree,
Just agree. I don't strongly agree because it's just the situation,
right? Can you think of a situation where you wouldn't?
Well, I had a situation where
it wasn't me, but my daughter.
Right.
Was leaving a restaurant that she had been working at about 1 o'clock in the morning, and she was on her way home. And cops stopped her, and she didn't understand why, because she wasn't breaking the law as far as she knew. But there were like 3 cops in a car.
Mhm.
They all get out, and they go to her door, and they want her to step out. And she's scared to death. She's a teenager, and she gets out, but it was just not right to me. She should have stayed in the car and told them she would drive somewhere safe where she felt safe where she could get out. So I don't agree on if an officer, you know.
So you would be able to exercise a reasonable standard in looking at the conduct involved, right? Whereas a reasonable use of force to effectively arrest whether the person is actually resisting the lawful use of force. Right. Yeah, I'm not disparaging law enforcement, it's a tough job. Obviously, there's a lot of problems that go along with it, but they're bad at, right? And, I mean, I think recently there was a BPS officer last week, maybe, that was arrested for sexual assault for over in Harris County for pulling women over and sexual assault. So I mean, there's limitations, there's always gonna be problems. And anytime you give somebody that kind of over, right?
Right.
Who represents you? If you look at Mr. Hoffmeyer, I keep picking on him with his PowerPoint, but when he walked in, it said, you know, Kobe Hoffmeyer, District Attorney's Office, represent the DA's office and the people of Jefferson County. Who do you think, do you go along with that? It's come on, I mean, he's a nice guy, I like him, we're friends, but do you think he represents the people of Jefferson County? Yeah. Who thinks Mr. Hoffmeyer represents the people of Jefferson County in this court, in this criminal trial? Ms. Bradford, what do you think? You think Mr. Hoffmeyer represents the people? You know, Ms. I'm gonna come back to you on the law. Ms. Sandoval, what do you think? Who represents the people?
I don't know if it matters. I'm Colvin on that.
I'm sorry.
I don't know if it matters.
It does, because Ms. Sandoval's not here. Ms. Collins, Katie Collins. Who do you think, Katie Collins, who represents the people?
He said he represents the state.
Okay, is that the people?
I mean, in a way, I guess we make up the state.
What's the state?
But then I guess the judge also too has got command of all, like you said, he's got all the actual,
What's the state? What is the state?
I would think the group of people, us collectively.
Is it the government? State's the government?
And so government, at least as people.
So you think the government and the people are the same thing? The executive authority, not their own people?
Yes.
What do you think, Mr. Brown? Who represents the people in here? Who represents the people in this? Mr. Hoffbauer? Me, the judge, who represents the people?
That would fall to the judge, I guess, as far as the hierarchy of it, but probably we do ourselves.
Who's we?
The jury.
The jury, yeah, right, that's who represents the people. All right. Right? Not Mr. Hoffbauer, me or the judge, the jury represents the people. You're the ones that get to say to law enforcement, hey, this was not resisting arrest, go back, try again, we're grading paper, this failed. This doesn't make it. We need more than this to convict a citizen and potentially lock her up for a year in jail on resisting arrest, something more than this, Mr. Law Enforcement. You set the standards for them, you represent them. Right, Ms. Collins, you see that? Well, I wasn't trying to trick you. Just trying to get the answer I wanted. I would submit to you, Mr. Hopper, I don't represent the people, I don't represent the people, I represent this court. The jury represents. I'm getting back to you, Ms. Bradford, you strongly support law enforcement. Kind of support them, neutral, don't support them, strongly don't support. Strongly does. Back and forth. Neutral, so you're free. All right. Ms. Colvin, what do you think?
I like to think that I'm pretty neutral.
Three, just kind of gonna judge and call it like a seven. You ever had a bad experience with law enforcement?
No,
Positive, any of your friends?
they're in law enforcement.
No, they've had a bad experience.
Not too personally direct to me, but I mean, you hear stories, kind of like you said, you've already given examples where. I mean, I think in every profession, kind of, there's always.
Right. You're comfortable looking at the evidence in this case, that Mr. Alfaro presents and making the judgment whether it will actually rises to the level of resisting arrest. It's setting the standard, your opportunity to set the standard for law enforcement in the community. That's you, Mr. Grant.
And probably neutral,
Neutral.
they choose their employment, so.
So they choose their employment,
Yeah.
they kind of take their lumps, yeah. All right, Ms. Randall Fowler. Support, stronger support. Which one? Which top, which officers? Which one? Which one?
Yeah,
Name.
Cameron Hayes, Chief, Mara,
Mhm.
Sergeant Mitchell.
This is the DISD officer. What about you, Mr. Edmondson?
That one strongly agreed.
One strongly agree, two is agree, three is neutral. Disagree,
Probably sound somewhere between 3 and 4,
three or four.
less agree.
A little skeptical.
Yeah.
Okay. That's good. Yeah, I understand what we're doing. Each side gets to eliminate 3 people off of the panel. The first 6 that you're left with is the jury. So we're not actually selecting people, we're like scratching people off. One of this all matters. Ms. Campbell, is that right? What do you think? 1 through 5?
I'm neutral.
3. Sitting on the fence. All right. Well, can you think of a situation that, maybe over the top of all?
Police officer, you're
Mm,
stories.
Which ones do you?
The lost on your phone line.
Okay.
It's very well exposed.
Is he a patrolman or what is he?
He's just a police officer.
Okay, what else?
And then, also friends with, Marco.
Yeah. Well, it used to be Fort Texas, didn't
Yes,
Yeah.
and also Cherie,
And Marlon lived next door to my brother. Anything about that that would affect your ability to be fair and impartial on looking at officers? Kind of.
You want to be fair. Both sides.
When you walked in here and when you were sitting at the table, you asked yourself, I wonder what she did wrong.
No, I just looked at her, I just, yeah, I guess, you do, I mean, I guess you look. Okay.
Voted right now would it be guilty or not?
I have to say not guilty, just because, I mean, because I don't have facts, you know.
Don't have Mr. Hopper and shows you anything to show otherwise. What is she right now? She's presumed to be innocent, right?
Yeah, absolutely.
Is that the same as not guilty?
Wouldn't be.
Anybody disagree with that? Is innocent the same as not guilty? Anybody, you're looking at my list. Gonzalo? Steven? Leanne, what's your name? I'm sorry, what? Gonzalez, okay. Well, you're shaking your head, no, it's not guilty. Are those the same thing or not?
I don't think they're the same thing.
What's the difference?
Honestly,
Did the juries find people innocent?
confused.
Did juries find people innocent? jury's finding people not guilty, right? So not guilty means there's reasonable doubt. In the case, Mr. Hoffbauer has not eliminated every reasonable doubt that you have that he's required to eliminate, right?
I'm sorry,
If you have reasonable doubt, what's your verdict? Anybody, there's reasonable doubt, what's the verdict? Does that mean innocent?
No,
What's the difference?
no,
Was OJ innocent?
absolutely.
Was OJ innocent? Didn't do it? Sure, certain? Anybody? Was he innocent? No. Is it possible to know? You weren't there, right? Who said he was even questioned by being a witness, Mr. Allen? Right, you don't know whether there was innocent or not. Was he not guilty? Yeah, the jury found him not guilty, not guilty. Not guilty doesn't mean innocent. Not guilty just means there's a reason for that. You know, it's not a certain. All right, that's the difference. So your vote would be not guilty to the judge previous case because of presumption of innocence. Mr. Payne, what do you think? Strongly support, neutral?
I strongly support them unless they're.
Listen.
I strongly support them and,
Why is that?
case by case, but I know you said, like you said, there's bad apples
Right,
and, but there's, bad apples and everything. But we need them there to uphold the law and do it the right way. Or else there will be anarchy. I support them,
strongly.
strongly support.
You think that you would be able to objectively evaluate the situation and say if a person actually resisted an arrest? Or would you be favored from the start to give law enforcement?
I would be able to check it. I know it's never really cut and dry. I said there's some bad apples and probably have different procedures or tactics or whatever. And,
Again, this kind of already been answered, what would your vote be right now, guilty or not?
yeah, say I haven't heard anything.
What does that leave you with if you haven't heard it?
Yeah, I'm curious because I haven't heard anything.
Well, is it guilty or not guilty? You haven't heard it?
Well, I would say not guilty.
Yeah, not
You
guilty,
can't say,
because you haven't heard it.
right.
All right, Ms. Gonzalez, strongly support.
I would say I'm neutral.
Neutral. All right. Ms. Schuler, what do you think? Neutral. Ms. Allen? Two, support. To the
Like it
extent-
says, there's bad apples in everywhere, lawyers, judges,
Sure.
everywhere.
Used car salesman?
Yeah, definitely.
All right. Do you agree with Mr. Tatum that we need law enforcement to enforce the laws to protect?
A little bit of everybody to check this.
Huh?
A little bit of everybody, you need judges like everybody.
So you're relying on the system,
Yes,
right?
to allow the system to do the right thing.
You still relying on the system these days?
Yes, not fight, but yes,
You comfortable with that? Are you confident relying on the system these days?
not as reliant as it used to be.
Right. You protect yourself, you might be charged with something, and then you have to say self-defense, and then maybe the system and again your tax, right? All right, I'm just gonna touch on reasonable doubt, and we'll sit down, give you a little bit of time back. Judge is not gonna define what reasonable doubt is, it's up to each of you to decide. I'm not even gonna tell you, I think he'll tell you that it's not proof beyond all possible doubt, but that's about as close as you're gonna get to that definition. I simply suggest to you that because the result of a conviction is potentiality of going to jail for a year. That how sure do you want to be if we want to subject somebody to the deprivation of their freedom?
Mr. Kimberly, you have 5 more minutes.
And again, it's not certainty, but because of what's at stake, I would suggest we set the standard as far as what resisting arrest is in this county, whether Mr. Hoffmeyer met his burden, and put that under the lens of beyond a reasonable doubt, that should be a very strong one, it's a very high standard. Everybody agree? Ladies? Thank you.
Okay. With 26 minutes and 10 seconds. Okay, ladies and gentlemen, we're gonna ask that you follow the bailiff into the hallway. We may have to call you back in or fill you back in and do some follow-up questions. So at this time, the court will be in recess. Everyone, please stand as the panel exits the jury room.
Let's enter the jury information.
Thank you.
You stand.
No, it goes to there. No, it
Can I talk to her?
didn't talk. They sit down with me and, yeah.
Okay, here we go.
Yeah.
Yeah, yeah, right out there.
Eric, they were really like, what's up? I go,
Okay, he's really, really good.
yeah, walk right.
Here we go. Did she call her name? Just sit in your same chair. Yes, sir. Yeah, you're gonna sit in your same chair. You sit in your same chair. Ladies and gentlemen of the panel, when your name is called, please have a seat in the chair that the bailiff will direct you to. Ms. Woodall. And there are some tags that's in the chairs. And when you get to the chair, you need to pick up the tag before you sit down. They got tags in each one of the chairs. Okay. Okay, at this time, you'll be in the hands of our court administrator.
Kirk Matthews.
Mr. Matthews, would you please come forward? And Mr. Matthews is gonna have a seat in that last chair in the back. Second row.
Kay Wall.
Kay Wall. Ms. Wall, you have a seat in that middle chair in the back row.
Lauren Bradford.
Bradford, you have a seat in that first chair in the second row.
Katie Colvin.
Bowman, you're gonna sit in the first row in that chair with the black and yellow tape on it.
Larry Crouch.
The Crouch. Crouch, you know, sit on that first row, chair with the black and yellow tape.
Cynthia Campbell.
Ms. Campbell, you're gonna have a seat in that first chair. Yes, right there. Yes.
Erica Schuler.
Ms. Schuler, I'm seated in that chair right there. Please pick up the tag. Okay. Okay, Ladies and gentlemen of the jury, I must now administer to you the second of the two oaths that I previously mentioned. So I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." You and each of you do solemnly swear or affirm that in the case of the state of Texas versus Catherine Cormier, you will a true verdict render according to the law and the evidence, so help you God. You did? Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions, interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I am the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it's simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Now you have badges. We would ask that you would wear those badges at all times, identifying yourself as a juror in this case. Ladies and gentlemen of the panel, those of you who were not selected as jurors in this case, I would like to thank you for your time and attention. I know you may have thought, or you may be thinking that I came to court, served on the jury, and I was not selected and I wasted my time. You did not waste your time. And the reason why I say that is because the way our system works, is we only could have a limited number of people on the jury. And we have to pick individuals who live in Jefferson County from the jury pool. So again, you have not wasted your time. Now, anytime you're in this area, please feel free to come and have a seat in County Court at Law number 2. I know that when you came here this afternoon, you looked over the top of the door and you said, oh, this is County Court at Law number 2. This is Judge Holmes' court. I'm in the right place. Well, this is County Court at Law number 2. You are in the right place. This is not my courtroom. This is the courtroom of the citizens of Jefferson County. And you are the citizens of Jefferson County. So anytime you're in this area, please come and have a seat in your courtroom. And you can sit in that area where you are seated now. We call that the peanut gallery. But it doesn't mean that you can come and bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on in County Court at Law number 2. I like to tell people that it's better than watching television. You'll be surprised and amazed as to what you hear and see in this courtroom. So our bailiff, she has some letters for you that she's going to give to each and every one of you. Normally, I usually give handshakes, but under the situation, we still have COVID in our community. However, I like to give what I call an air handshake to each and every one of you. Okay. All right. Thank you. Now, again, when you're in this area, please have a seat in your courtroom. Again, on behalf of the citizens here in Jefferson County and the staff here in County Court at Law number 2, I'd like to thank you for your time and attention. At this time, you'll be in the hands of the bailiff. If you need anything from the district clerk's office, they are still open. And you can go over to the district clerk's office and they can give you whatever you need. Again, thank you for your time and attention. And every one of you, please have a blessed day. And nice seeing some of the people that I know out there on the panel. Y'all have a blessed day. All right. You're excused. Now, I should add that if you want to sit and watch the trial, the case is going to start back up at 1:30 tomorrow. You can come here in court or you can watch it on YouTube on our court channel. Now, yeah, you may be seated. Now, ladies and gentlemen of the jury, this case is going to start back tomorrow at 1:30. And the reason why we start back at 1:30 is because the state is going to put on its testimony. The state is going to do their opening statements. And in the morning, we have a docket with other cases. And so what we normally do, we usually take care of those cases in the morning. Instead of having you wait outside while we're taking care of all of those cases, we usually just have you to come back at 1:30. So at this time, the court will be in recess. Will everyone please stand as the jury exits the courtroom at 1:30. When you come back tomorrow at 1:30, just have a seat outside the courtroom and then the bailiff will come and get you. All right. Y'all have a blessed day. Yeah, you're gonna make sure you bring your tags with you. Court will be in recess.
Sherry. Joan.